Hello, my friends. Thomas with Alpha Concepts here. We're going to record a video we're going to talk about 19 different court cases that are going on right now in the state of Illinois. We're going to talk about, of course, the assault weapon ban. There's multiple cases talking about the Illinois assault weapon ban. And we're going to talk about other cases as well. There's been a lot of people asking about the status of the assault weapon ban. Today we had oral hearings in one of the federal cases. We're going to talk about suppressors, red flag laws. We're going to talk about the FOID card. Is it constitutional or not? There's been a few cases about that. Highland Park assault weapon ban, Cook County assault weapon ban. We'll talk about all of these things. Like I said, we'll be talking about 19 different cases in today's video. We're not going to spend too much time on this. I'll tell you guys straight up front that the process is very slow. Court cases take a while to litigate. So don't be depressed if we don't have immediate results, immediate action. Like I said, these court cases take a while to litigate. So let's just go through them. I've got a spreadsheet here in no particular order. It's completely random. This is just a spreadsheet I use for tracking these cases, and I'm just going to share it with you guys, and we're going to go through it and just kind of give you a status update for each one of these cases. All right. Starting with our first case, we have the Barnett versus Raoul. This is the compiled federal case in the Southern District of Illinois. There are 5 cases that were merged into one. We can see lower on the screen here, we have these merged. These cases are all merged together. The Barnett versus Raoul. They are challenging the Illinois assault weapon ban. They are challenging the Illinois Protect Communities Act, which bans most semi-automatic firearms in the state of Illinois. I've done videos on that. Today we had oral arguments. The arguments took multiple hours. I want to thank first off Bishop on Air for tweeting real time. He was there. The judge, for whatever reason, decided not to broadcast the oral arguments. There is actually a telephone line that you can call in and hear. I waited on hold for an hour. It was supposed to be scheduled at 1. It wasn't until about 2 o'clock that I realized what was going on. They weren't broadcasting. It was actually scheduled for 1. They rescheduled it for 1:30, and then they decided not to broadcast. So I discovered Bishop on Air was tweeting in real time as best as he could the oral arguments. Definitely check out his Twitter channel if you want to read what the people were saying. Again, as best as he could. It wasn't 100% real time, but he did an excellent job. So when we talk about the Barnett versus Raoul case, it took a few hours first for the oral arguments. I think the judge was fair. He started by grilling the plaintiff's attorney, asking questions that you might want an anti-gunner to ask, playing devil's advocate. The attorneys were answering the questions, and then they took an intermission and they went to the state's attorney. The state's attorney, again, he was grilling the state's attorney on some questions. The state's attorney was making arguments. In my opinion, I'm not going to go into all the details. As I said, check out the Bishop on Air Twitter account if you really want to play by play. In my opinion, the state's attorney did not prove that the law was unconstitutional. So these oral arguments were basically what they were asking for is a temporary restraining order. I feel, just a guess, just a bet, but I feel very favorable that the judge might issue a temporary restraining order blocking the Illinois Protect Communities Act, blocking the assault weapon ban. Now, that's just a guess. The judge can rule however the judge decides to rule. Having said that, it could take days, it could take weeks to get the judge's decision. So, of course, we'll keep you posted on that, and I would recommend following the Facebook for those types of updates. If it's not something major, I wouldn't do a video about it, but if it is something major, I would. So, of course, subscribe to this channel, check the Facebook for those updates, and when the judge does give us some kind of ruling, I'll give you a status update on that as well. Having said that, we definitely know that no matter what the ruling is, be it favorable or unfavorable, we are going to have an appeal. There are, again, numerous different groups that are challenging this. The ILF NFFL, the National Shooting Sports Foundation, Firearm Policy Coalition, Second Amendment Foundation, National Rifle Association, Gun Save Lives, Illinois State Land Rifle Association, Illinois State Rifle Association. So many different groups. Whatever the outcome is, they're going to appeal this. If it's not favorable, you can bet that the gun rights groups, the firearm freedom groups, are going to appeal this. If it is favorable, that's great, but the state is going to appeal it anyway. So we'll see what happens there. Going down the list, we have the Anderson versus Raoul case. This is about suppressors. This is about the ban on sound suppressors in the state of Illinois. This is in the Southern District. I believe a few days ago, last week, the same judge that is hearing the assault weapon ban in the Southern District is also hearing the suppressors in the Southern District, and he decided to put a 90-day stay on this case pending the outcome of the Barnett case. I don't personally see how the two are interconnected. I think that realistically, it's just the judge not wanting to kind of get overwhelmed, to be 100% honest with you. But regardless of his reasons, he did put a stay on that case, 90 days pending the outcome of the Raoul, the Illinois assault weapon ban. Which brings us down on the list to Morse versus Raoul, which was actually filed before the Anderson. The difference is the Morse, again, is about suppressors, but is in the Northern District. We're still in all of the pretrial stuff that goes on. There was a mandatory mediation. The mandatory mediation was waived by both parties. Originally, we were supposed to see a trial in June of 2024. I would imagine that because the mediation was waived by both parties, that we're going to see that date, that June 2024, accelerated. But we'll see. Nothing is set in stone when it comes to these court cases. We're totally at the mercy of the judges. So again, we've got two cases about sound suppressors, the Anderson and the Morse case. One is in the Southern District, one is in the Northern District, and they're going through the motions. These things do take time. All right, so moving down the list, we have the Viramontes versus Cook County. As of right now, we're still in the pre-trials. Everything is just, moving along. Nothing is set in stone. There is a process. There is a procedure. Both parties have to go through the process. That's why these things take time. The Cook County assault weapons ban has been disputed before. There has been a case, I believe off the top of my head, it was Wilson versus Cook County. That was pre-Bruen ruling. And of course, we can change the arguments. The arguments have been changed. We're going to see what happens with the Cook County assault weapon ban. Having said that, if the Illinois assault weapon ban is settled before the Cook County assault weapon ban, that might rule the Cook County ban moot. We'll see how the judges actually decide in their wording. But these things take time. It's going to take many, many months, if not years. So moving down the list, we have the Naperville assault weapon ban. That's Bevis versus Naperville, law weapons. Originally, this case was dismissed at the federal circuit level in the northern area of Illinois, the federal courts. I believe, reading the ruling, that the judge did not take into account the new Bruen standard. Having said that, it already has been appealed, and we are going to see oral arguments in the appeal for June. You can see now how these things evolve. No matter who wins, no matter who loses, they get appealed and then they get appealed again. So all of these things take time. Something to note about the Bevis case is they did incorporate, this was filed before the Illinois assault weapon ban passed, and having said that, they did incorporate the Illinois assault weapon ban into their case. So it's interesting because, again, the Naperville ban specifically is one set of rules. It's an ordinance. And the Illinois assault weapon ban, as I said, they've incorporated that. So we'll see. It's kind of like a race to the finish line. Everybody wants to get the glory. I hope all these groups work together, coordinate with one another, because ultimately, at the end of the day, it's good for all people of Illinois. It's good for all firearm businesses of Illinois that we win. Glory set aside, I get why they want the glory, but glory set aside, we ultimately need a win. We can't be throwing bad cases, and that's not to say Beavis is a bad case. That's just to say that I hope these groups start to work together. All right, moving down the line, we have the Weiner versus Kelly. Again, we're still in pre-trials. There have been extensions for time. The state is saying they need more time. I wish that our side would play hardball and not just bend over and grant them these extensions. I have to assume that our side is spread pretty thin, just as their side is. I get nothing out of this, but I'm going to tell you this: if you care about your firearm freedoms, you might want to pitch in a couple of dollars to the groups that are fighting these lawsuits. I'll give a list at the end of the video to the groups, but they need our support because they're spread thin just as the state is. The difference between us and the state is the state has pretty much unlimited resources through our tax dollars, and these groups do have limited resources based upon our donations. So like I said, at the end of the video, I'll give you a list of the groups that are fighting these laws that take away our freedoms. So again, red flag abuses, basically, if you're not familiar with red flag laws, the state can take away your firearm freedoms. The state can take away your gun rights without due process. So that's a violation of multiple constitutionally protected rights, and that's something that we cannot allow to stand. So Weiner versus Kelly, I am being optimistic. Again, like all these cases, it's going to take time. So moving down the list, we have the Calkins versus Pritzker. State Representative Calkins filed a lawsuit in state court, not federal court, but state court. Now, here's something you have to understand about the Calkins lawsuit. He didn't ask for a temporary restraining order. Calkins asked that the Illinois Protect Communities Act, the Illinois assault weapons ban, be ruled facially unconstitutional. Now, here's the thing. In my opinion, originally, I thought that this would apply only to the named plaintiffs on the lawsuit. However, I spoke to a former attorney, Joel Brodsky, and he sent me a very extensive email that explained in great detail why facially unconstitutional applies to everybody. He also explained in great detail how the appellate court, who was the court that ruled it was facially unconstitutional, has the authority to rule a law facially unconstitutional. Now, there's a difference between facially unconstitutional and unconstitutional, and facially unconstitutional means it applies to everyone as if the law never even existed. Having said that, in my layman opinion, I'm not a lawyer, but that means that the Illinois assault weapon ban is temporarily on hold pending the outcome, because it's going to go to the Supreme Court next, the Illinois Supreme Court, pending the outcome of the Supreme Court. I'm not a lawyer. I'm not going to pay your legal fees. I believe it is null and void at this point unless the Illinois Supreme Court rules differently. There are gun stores that agree with that opinion. There are gun stores that are selling firearms as if the law never did exist. The Illinois State Police are aware of that, but it's interesting because the Illinois State Police have said this only applies to named plaintiffs. Attorney General Kwame Rule has said this only applies to named plaintiffs, and the governor has said this only applies to named plaintiffs. But in my opinion, that's kind of like the fox watching the hen house. What I mean is, it's the government who took your rights away, and now the government is the same party saying that, no, this doesn't apply to you and I. Make of that information what you will, okay? I believe that it applies to all of us. Having said that, the government might disagree. I think it's a case you can win, but I think it's a case you're going to spend thousands of dollars to win. So as I said, make of it what you will. Moving down the list, we have the Accuracy Firearms versus Pritzker. All I'll say about this is if you have any questions about this, the ruling only applies to named plaintiffs. If you are a named plaintiff, if you did pay $200 to get your name put on the list, then if you have any questions about this case, I would recommend reaching out to your attorney who you paid to represent you. They can answer any of your questions about that. My understanding is that they're going through pre-trial. It has been appealed, etc. They're in discovery. They're asking the state for information. Some of that information they'll get, some they will not. What they're trying to do is bolster their case. Like I said, if you have any questions, if you are part of the DeVore case, if Thomas DeVore is representing you, then reach out to his legal team and they'll be able to answer any of your questions. I cannot. Moving down the list, Schoenthal versus Raoul. This is about the ban on concealed carry in public transportation. I think this is the number one place that anybody who carries a concealed firearm might need that firearm. I avoid public transportation like the plague. There's nothing good happens on public transportation. Having said that, there's millions of people in Illinois that have to take public transportation. And public transportation, specifically the CTA, the Chicago Transit Authority, is a bloodbath. This is the number one place that you might need to use your firearm. There have been people with concealed carry licenses who were illegally carrying their firearm because public transportation is a gun-free zone, and they have used their firearm in justified acts of self-defense. I'm not advocating for anyone to break the law. However, as I said twice already, I'll repeat a third time, this is the place you're going to need it the most. Thank God that the Firearm Policy Coalition, the Second Amendment Foundation, and the Illinois State Rifle Association Legal Assistance Committee decided to finally do something about this. The interesting thing is in 2014, the ISRA vowed that they were going to fight the ban on public transportation, and then in 2015, they didn't say a damn word about it since. Here we are, 2022, I believe, was when in November, if I remember correctly, was when the lawsuit was filed. So again, everything's in pre-trial. We'll see how things go. I honestly believe that due to the Bruen ruling, that ultimately we will be successful in this ruling. But it's going to take time, so we'll keep you posted on that. So again, Schoenthal versus Raoul is about the concealed carry ban on public transportation, and we'll see what happens, but I think it'll be successful in our favor. Moving down the list, we have the Meyer versus Raoul. This is regarding concealed carry for people who are less than 21. So people who are between the age of 18 and 21 are legal adults. However, they cannot apply for a concealed carry license. This has ramifications for people who are who are emancipated minors. This has ramifications for people who might be military, who officially reside in another state but are stationed here in Illinois. This has ramifications for anyone who is, again, technically a legal adult but cannot protect themselves. They are disarmed by law. There was recently, I believe it was Missouri, a favorable judgment that said that it was unconstitutional to block adults who are over the age of 18 from carrying firearms. That ruling was entered into this case as evidence, so we'll see what happens. This is in federal court, so it seems like it's probably going to be favorable, but we're going to have to watch and see. And just like every case, understand it will be appealed. No matter who wins or who loses, it will be appealed. So these things are going to take time. Miller versus Smith. This is about the daycare ban. Having firearms in your home if you are running a daycare out of your home. So it's been appealed, and then it was remanded back down to lower court. Why was it remanded to lower court? Basically, the judge said, apply the Bruen standard. The Bruen standard that I've talked about a few times already is the New York State Rifle and Pistol Association versus Bruen. In 2022, the United States Supreme Court had a very sweeping ruling talking about how to weigh the constitutionality of firearm freedoms. So this case was pending. It was filed pre-Bruen, and the judge basically said, hey, let's send this back down. Bruen wasn't part of the argument. Have them argue Bruen, and then let's see what happens. So that's where we're at right now. We're waiting to see what happens. So that's Miller versus Smith. We have Atkinson's versus Garland. That's a case that is being heard regarding the possession of firearms by ex-felons. Now, I can hear the air getting sucked out of the room right now. People are like, oh my God, felons in possession of a firearm. But the reality is this: anybody who is evil will have possession of a weapon, including a firearm. And despite what many people might think, some felons have been rehabilitated, and I personally know some of them. And they cannot protect themselves. They cannot protect their businesses. They cannot protect their families due to one mistake that they may have made when they were teenagers. Anyways, long story short, however you feel about that, there is a case right now that that is pending, and it is under advisement. As of November of 2022, under advisement. So what does that mean? Well, that means that we're awaiting a ruling. And then, of course, as I said many times before, no matter how that ruling is issued, it's probably going to be appealed. So felons, as I said, in possessions of firearms, my personal opinion, you can agree or disagree. At some point, have you paid your debt to society or not? If you stole a car, that's one thing. If you murdered someone else, well, that's another. But the bottom line is, if you're too dangerous to have access to firearms, what are you doing walking the streets? Shouldn't our criminal justice system be about reform? That's a whole other topic for another video. So let's just move on to the next case. We have Gun Save Life versus Raul. Gun Save Life versus Raul, I believe, was filed in 2019. This is another case that was basically, it was ruled, it was appealed, and then because of the Bruen ruling, they said basically, let's remand this back down to lower courts, apply the Bruen standard, let's see what happens. Now, I searched and I was trying to find a date for this case. I couldn't find it. I reached out to a friend of mine who is one of the chair members of GSL. He basically was not aware of what that date was. He said he was going to get back to me, but he didn't. I wanted to get this out, today, because of the oral arguments on the assault weapon ban that everybody was waiting for. Bottom line is, it's no time soon. Okay, so like I said, I was unable to find the date. He said he'll get back to me. Something I'll probably just throw up on our Facebook page when I get that information. Moving on down the list, we have Keneally versus Raul. This again is about an assault weapon ban. I'm apologize in advance if I pronounce your name wrong, Keneally. The state is requesting remand for the federal, from the federal courts back down to the state courts. Basically, they're trying to move the lawsuit out of the federal courts back down into the state courts. We'll probably have, I'm going to guess, we're going to have a decision in mid-May. We'll see what happens. Again, this is regarding the Illinois assault weapon ban. What's interesting, though, you'll see this is interesting, is this has been filed by the Attorney General, the McHenry County Attorney General. He's challenging this assault weapon ban, the Illinois Protect Communities Act. So we'll see what happens. Like I said, the state is dancing back and forth. They want to move it down to the state level. So we'll see what happens. We have Rogers versus Hacker challenging the Illinois FOID card, the concealed carry license, and the melting point law. So we've got a big, possibly sweeping case. Things merged all together. They're asking for a temporary restraining order. We'll see. We'll see what happens with that. The Illinois melting point law, for those who are not familiar, bans the sale of firearms that are made with a zinc-lead alloy. That's what we call ZAMAC. That zinc-lead alloy, this law went into effect in the 1970s, if I remember correctly. The Saturday Night Special law. The bottom line is, it was designed to ban affordable firearms. I've said before, if you follow this channel, that gun laws are racist. This law was designed to keep firearms out of the hands of the poor and the working class. They want these people to be dependent upon the government for their protection. Check out the video I posted talking about the origination of the FOID card back in 1968 and how the FOID card was based in Mayor Daley's racist desire to keep the guns out of the hands of non-whites. A few years later, we have another law banning affordable firearms. You know, the argument made is these guns are unsafe because they'll melt if you shoot them too much. Fast forward to the era of Glocks and polymer firearms. These guns melt at a much lower melting point than lead and zinc. But here we are anyways. So there is this case, this Rogers versus Hacker. As I said, this has the potential to be a very sweeping case challenging the FOID, the concealed carry, and the melting point law all in one. So let's see what happens with that. Going down the list, we have the Singleton versus Kelly. Singleton versus Kelly was mutually dismissed. The reason it was mutually dismissed was because of the Fix the FOID. That is a bill that passed in 2021. There had included sweeping changes to the FOID card, to the concealed carry license. It forced the Illinois State Police to hire additional staff to process these licenses, these permission slips to exercise our freedom in a timely manner. Because the Illinois State Police now is finally once again processing our freedom slips in a timely manner, both parties have agreed to dismiss the case. So Singleton, as of this point, is dead. We have Herrera versus Raul. This is about the Dr. Herrera filed a lawsuit challenging the Chicago assault weapon ban, the Cook County assault weapon ban, and the Illinois assault weapon ban. So we have 3 assault weapon ban challenges in one. If I remember correctly, there was a push to try to merge this in with Beavis and merge this in with Highland Park, but the state was trying to merge them, if I remember correctly, and it was not successful. I could be wrong on the state wanting to do that, but I do know it was not successful. So I believe, according to my notes, that there's going to be a hearing regarding the temporary restraining order of the Cook County assault weapon ban, Chicago assault weapon ban, and Illinois assault weapon ban April 17th. We shall see what happens about that. Moving on down the list, we have Goldman versus Highland Park. Goldman is challenging the Highland Park assault weapon ban. Highland Park the city of Highland Park is attempting to reassign that case, as I just mentioned. We'll see what happens with that. A lot of judicial dancing back and forth. They try to delay these cases as long as they can. So again, this is challenging specifically the Highland Park assault weapon ban. We have Davis versus Yachenko. That is regarding revocation of your FOID card, revocation of your concealed carry license for arrests. Now, here's the thing. We have this thing in this country, it's called due process. Due process says, summary, you are innocent until you are proven guilty. The state has to prove your guilt. In my opinion, you should not lose any rights until you are proven guilty. However, that's not the way that firearm freedom works in Illinois. If you are arrested for various different crimes, if you are arrested, even if charges are dropped, if you are arrested, they will revoke your FOID card, they will revoke your concealed carry license, and then you will, even if they say, oh yeah, charges are dropped, sorry, our mistake, you'll have to go through the dance to get your permission slips back. Davis versus Yachenko, this was ruled unconstitutional in the Third Circuit. The state is going to appeal, and they have until the 12th of April to appeal this. I say they will appeal. I'm not a fortune teller. Today's the 12th. I did not have a chance to see if they appealed yet. There was too many other things going on with the Illinois assault weapon ban. I'm going to guess right now. We'll put it in the comments if I'm wrong. I'm going to guess right now they did appeal. If they did not appeal, then what does that mean? Well, that means that if you're arrested, you should not have your FOID card revoked. You should not have your concealed carry revoked. We'll see what happens with that. That's one of those updates I'll have to get back to you. We have the Harrell versus Raul, Langley versus Kelly, Barnett versus Raul, and the FFL-IL versus Pritzker. Those were all merged into that Barnett case. So we have 5 cases merged into one, challenging the Illinois Protect Communities Act. Then moving on down the list, we have Vandermeide versus Cook. You might know Todd Vandermeide as Gun Santa or Freedom Steel. He has an excellent channel on YouTube. He does a better job than anyone breaking down, sometimes in minutia, the laws, specifically judicial rulings. He's going to give you more up-to-date information. I kind of want to give a big picture, and he kind of gives more bite-sized chunks. So long story short, Todd did file a lawsuit against Cook County, their quote-unquote violence tax. If you buy a firearm from a gun store in Cook County, you're going to pay $25 on top of the cost of that firearm, and that doesn't include the sales tax. So you still have to pay sales tax. That's a violence tax because law-abiding gun owners are out there shooting up the streets. And then if you buy ammunition, you're going to pay 5 cents a round if you buy ammunition in Cook County. So Todd challenged that. It was dismissed. Todd stated to me that he is going to refile. I haven't seen that filing yet. But definitely I'm looking forward to it. This is the second challenge to the Cook County tax. The first challenge was successful. However, the argument from FFLIL was based upon the constitutionality of the tax. In my opinion, they argued incorrectly. They went for a low-hanging fruit, and they won. So who am I to argue? But on the bottom line is once they were ruled unconstitutional, the state revised the ordinance. The county revised the ordinance to make it constitutional. Basically, the bottom line was originally they were saying, well, it's unconstitutional because the tax is not applied to something specific as a general tax. You can't do that. Okay, it's unconstitutional. And then they said, okay, well, now we're going to apply it to something. They reinvented the tax, and here we are today. Todd challenged it. It was dismissed. Todd stated he's going to refile, so let's see what happens. We'll keep you posted on that for sure. Dropping down to the last one on our list, I know I said there was going to be 19, but I wanted to give you some of these other cases that are dismissed just so you kind of understand what's going on. There is Lucy, I'm guessing, sorry if I said the name wrong, Lucy versus Kelly. That was regarding, again, concealed carry license delays. That also was mutually dismissed, mutually dropped, again, because of the Fix the FOID Act and because the state police are finally processing permission slips in a timely manner. So that rounds things out. Let me tell you guys something. I've been following these cases for years, for 12 years now, okay? And in most years, there's 3, 4, 5 cases. This year, because of because of the Illinois Protect Communities Act, everybody is fighting this, and that's awesome. That's a good thing. Because of the Bruin ruling, it opened up to a lot of arguments to things like sound suppressors and public transportation. So that's also a good thing. I want everybody who is still watching this, almost 30 minutes later, whatever it is, I want you to be patient. I know that's hard to say. This sucks, but this is temporary pain, okay? I believe that most of these cases are going to be successful. Some of these cases are obviously very redundant. Let's just imagine, for example, the Illinois Protect Communities Act is ruled unconstitutional, as I absolutely believe it shall be. At least great, vast majorities of the law. Again, it's 111 pages. Even if 110 pages are ruled unconstitutional, I'll consider that a win. I believe things like red flags are going to stay. I believe things like the universal background checks that go into effect July 1st are going to stay. These things are not being argued in this case. These things need a separate case to be argued. For example, the red flag law case that we were talking about, the Weiner versus Kelly. So it's a process. It takes time. If we get a temporary restraining order at the federal level, things will go back to normal, at least temporarily. If Illinois Protect Communities Act is ruled unconstitutional, that creates greater argument for the Chicago, the Cook County, the Highland Park, the Naperville bans. Let's just watch what happens. Our faith right now is in the groups that are protecting our rights. And as I promised, I said I would give you guys a list. So this is in no order. It's completely random. And I'm just going to throw some groups out there that are currently or have fought for our rights. our firearm freedoms in the state of Illinois. You have Firearm Policy Coalition. You have the Second Amendment Foundation. You have FFLIL. You have the Illinois State Rifle Association Legal Assistance Committee. If you're going to give money, I would give it to the Legal Assistance Committee. Gun Owners of America have jumped on the bandwagon with the Illinois assault weapon ban. You have the Illinois State Rifle you have the Illinois State Line Rifle Association. You have Gun Save Lives. I'm sure I'm going to forget a few, and if I do, I will update the description to include those groups. There has been a conglomeration. Oh, the National Shooting Sports Foundation. They've been involved in a few cases. They're involved in the assault weapon ban as well. There have been many of these groups have been merged, not merged, but for purposes of fundraising, merged into the Illinois Gun Rights Alliance. If you're going to give to one group, that might just be the best bet. They're the group that, they probably 5 of the names I just listed are part of the Gun Rights Alliance. So I just gave $100 the other day. 2 days ago, I gave $100. I'm not a wealthy man. It was not an easy thing to do. But these cases cost money. And there's so many cases. I mean, there's cases that, man, if I won the Powerball tomorrow, I would start challenging. There's so much low-hanging fruit that I see that we could win, but it takes money. And this is not a fundraising video, but we just have to get active. Throw $20. Pick one of the groups, throw them $20. That's all I can say. I don't care which one. Pick one of the groups, throw them $20. All right, guys, long video. I did not think it was going to be this long. That gives you the summary of everything that's going on. If there's a case that I missed, I'm leaving out one case that's very important, but I was asked to leave it out. I hope he wins. I think he's going to win. Can't wait for the day that he does win. Then favor to him. I'm leaving it out. He asked me to leave it out. So it'll be big deal when he does win. But anyways, long story short, these things take time. Be patient. Support the gun groups that are supporting us. If you know of any other cases, leave a comment. If you have any other questions, leave a comment. I'll do my best to answer those questions. This crap has turned into a full-time job. I've got a firearm training business to run, but it's important. This is important. So I hope this video was helpful to you guys. If you made it this far with me, it's been a long, long time. If you made it this far with me, I want you to hit the subscribe button, hit the like, share it with your friends, and I'll catch you on another video. As always, everybody, be armed, be trained, and be alpha.